All right, guys. Day 8 has wrapped for Tory Lanez's felony assault trial. Here's a recap. Okay, so both parties have entered in their closing arguments. Prosecution went first, the defense went second. At this point, I really do feel like the prosecution gave compelling closing arguments. I think they really did a good job of pulling at the heartstrings of the jurors and really making them feel a sense of emotion for Megan, feel sorry for Megan and what she's gone through the last 2.5 years. I think they also did a pretty good job of refuting this idea that Kelsey was the shooter. In the meantime, I thought I'd also interview someone who knows a thing or two about high profile cases, the one and only Carl Douglas. He was a part of the O.J. Simpson defense team, AKA the Dream Team. He's also had clients like Michael Jackson over the 42 years that he's been a trial attorney, and he's an amazing attorney. So I thought he'd help us answer some of the questions that I have and see what he thinks about the case thus far. Let's start with this. It is the people versus Daystar Peterson.
That's one of the misconceptions that often comes about with these high-profile trials, especially if the victim, in this case, is herself high profile. She is simply a witness in a prosecution that the DA's office is presenting on behalf of the people of the state for this violation of law that they accuse Tory Lanez of having committed.
When Kelsey Harris took the stand, she was granted use immunity, and the word kept being thrown around. And so I really wanted to have you kind of explain what that means versus transactional immunity, because she was not given that.
Use immunity is nothing that you say will be used against you so long as you tell the truth. If she talks about some other grand scheme or something else, or they find something else, that's not going to give her that kind of the transactional immunity, which is more broad. But the use immunity gives her the protection that she was asking for, so that nothing she said, so long as it's factually true, would be used against her. Now, given that she had that immunity, it was still unfortunate, the approach that she took.
Because she pled the fifth several times. She asked the judge if she could use her fifth when she was being questioned. Yeah.
And then she had selective amnesia, we call it.
Yes, she did. She did.
And it really undercut the strength of her believability as a witness.
The judge also used a term that I want you to explain too. He also said that he used the word impeach, right? So, and that he was allowing the audio recording to be played.
Because she said, I don't remember if I said that, or I didn't say that. Oh, no, but back before this court date, before these cameras, you did say this. So now, are you lying then, or are you lying now? In essence, what it is. Mm-hmm. It is impeaching her. It is forcing the jury to see what she is saying now in front of you is a lie, and what she said earlier with her lawyers on the phone in front of her husband is really what happened.
Right, right.
Coupled with the text. You can't get around the text message because that's in real time.
You were a part of not only OJ, but also Michael Jackson's, these were huge trials. Talk about just some of the difficulty in being able to do that with cameras, rolling every single day, because there's no camera inside of this trial.
It's no comparison to the O.J. Simpson trial. One, let's be clear with that, okay? Yes. Okay. We were in trial for 9 months, not 9 days. It's a very, very stressful sort of circumstance. And it's made even more so when there are cameras in the courtroom, or if your client is someone that is high profile, because this really is not the kind of publicity that they welcome or that they enjoy, though it can, in a weird sort of way, give them a kind of a credibility edge, particularly for a Canadian rapper like Tory Lanez is.
Yeah.
I'm saying give him a little cred, but when you're facing the possibility of 22 years in jail, you don't need that kind of drama, I don't think. And it's a real tough case for his side to win. Looking at the facts, somebody shot Megan.
Mm-hmm.
And to think that her assistant pulled out a gun and shot her employer, to me, defies logic and common sense. And the jury is not supposed to leave their common sense in the parking lot.
So let me ask you this question. Would you have taken this case?
Every person charged with a crime is entitled to a defense. The prosecution has the burden of proving someone guilty. The phrase is beyond a reasonable doubt. But the key word is not reasonable. The key word is not doubt. The key word is beyond. They have to go beyond a reasonable doubt.
So I want to get your thoughts on the DNA findings.
That it is inconclusive means there are not enough points of similarity for a doctor to call it. The threshold has not been reached. That's different than he has been excluded. In
your opinion, was that a smart move for him not to take the stand?
I would say in 95% of the time, it is in the defendant's best interest to not take the stand, because you want to do nothing that would shift the burden of the prosecution to prove someone guilty beyond a reasonable doubt. And regrettably, if I have a twitch, or if I stutter, or if I'm not able to look and to be as persuasive just because I'm nervous, people may misinterpret that as being evidence of guilt.
I want to go back to Jaquan really quickly, just to clarify. He's the fourth person in the car, right? And so far, we know Tory's not going to testify, but we've heard from Megan and we've heard from Elsie.
Two things. One, the prosecution didn't know what he was going to say, and they didn't want to take a chance. And two, Tory wouldn't want to have him talk if Tory's guilty.
Yeah.
And they found him because he was avoiding being served a subpoena. But a witness does not have to talk to a police officer or a district attorney until he's on the witness stand. And a district attorney does not want to put an important witness on the witness stand not knowing what he's going to say. When you have a circumstance and there is a limited field of information, 4 people in a car, there is a gun in a car, there was a gun fired, somebody got shot, somebody did something wrong, okay? So, and that on that level, it's a very simple case. She didn't shoot herself. Okay. Now, did they prove that Mr. Lane shot him? Mr. Smith, maybe, or Ms. Harris? That's the question. But it's a simple case.
Mm-hmm.
Okay. The goal of the defense is to make it unsimple and to generate as many areas of doubt as they can.